Now, in the event you're unwilling to meet or to reconsider the directive in light of the problems raised by Bove, I am prepared to offer my resignation. The DOJ will not tolerate insubordination and apparent misconduct, all reflected in the approach that you and your office have taken in this matter. We're reading this going, what? He got like upgrades and stuff? Like, okay, he probably got some financial benefits and so on and so forth, but he didn't do anything worse than Fannie did. Federal prosecutors now shown the door. This so-called prosecutor, Danielle Sassoon, no longer going to be with the DOJ. Goodbye. This is a good start. She now exits the courthouse. This was a photo from a year ago, but CNN is telling us, who is Danielle Sassoon? She quit amid a directive to stop the Eric Adams corruption case. Okay, so she was there, Southern District of New York, and Trump came in. They got an order from on high, get rid of the Eric Adams case because it was created out of corruption. Remember, Eric Adams started to not be in alignment with the Biden administration when they said, you need to take every single illegal alien that comes across the border and don't even complain about it. He says, well, we can't really afford it. They said, how about we indict you since you're back talking to us? Then they indicted him. Obviously, it was political, and we got no love for Mayor Adams or Democrats in New York. Like, enjoy your sanctuary city. Just don't make us pay for it. Good luck. But what they were doing was taking our money and having our country infiltrated and invaded by foreign aliens, right? That is a problem for us. And so Adams was a part of the problem, but the DOJ, of course, is obviously also corrupt and a huge part of the problem. So we're kind of caught between a rock and a hard place there, but I digress. She sent this. She says, okay, Pam Bondi, says whiny prosecutor. On February 10th, I got a memo from Emil directing me to dismiss the indictment against Adams. Now, I'm not going to repeat the evidence that proves he did these things, but Bove never called into question that this investigation occurred, and there is support here that's serious in fact and law. But Bove's memo directs me to dismiss an indictment returned by a duly constituted grand jury, which again means nothing, because as you heard the phrase, you can't indict a ham sandwich. So they always say like a duly constituted grand jury. Yeah, well, we know what you guys do to grand juries there in New York. We know what kind of evidence you present, all right? And we have evidence of that from the Trump prosecution, where the lawyer, Robert Cohen, who was representing Michael Cohen or working with Michael Cohen, was brought in to testify in front of the grand jury there and explain what a joke it was to all of us. So no one cares about your little grand juries, okay? You guys have perverted the justice system. So you can't come back and constantly rely on these things and all of us just sit here like, we used to, like, wow, I guess there was some process, right? 20 years ago, well, it was a grand jury of our peers, it's not weaponized. No one cares anymore. So just keep saying that. New York, it's a joke. For reasons having nothing to do with the strength of the case, raises serious concerns that render the dismissal inconsistent with my ability and my duty to prosecute federal crimes. Now, when I took my oath of office 3 weeks ago, and I guess she's like brand new, or did she retake it when Trump was inaugurated? Maybe they retake them. I vowed to well and faithfully discharge my duties. Now, I'm guided, among other things, by the Justice Manual and the values that have defined, so it's just a re-swearing, of my 10 years of public service, which again, it's like, yeah, we also are knowing what that means, okay? What 10 years of public service looks like, right? All the civil servants are getting a second look too. Now, you and I have yet to meet Pam, let alone discuss this, but as you know, I clerked for Wilkinson, 4th Circuit, and Antonin Scalia. Don't you dare besmirch his good name. On the U.S. Supreme Court, both men instilled in me a sense of duty to contribute to the public good and blah, blah, blah. I've always considered it my obligation. I therefore deem it necessary to the faithful discharge of my duties to raise concerns expressed in this letter. And now I'm concerned, right? If you want me to dismiss this, then I have to raise an objection, which is what she's doing. Says Emil wants me to dismiss these charges, saying that it's the same thing as a Russian's arm dealer with Victor Boot and blah, blah, blah. Federal prosecutors may not consider, okay, so she's going to give us a lecture, which we don't really care about. So she's going to say, for the reasons above, I do not believe there are reasonable arguments to dismiss this. Now, I understand Bove disagrees. I'm mindful of your recent order reiterating our duty to make good faith arguments, but I cannot make these arguments. And the rationale given by Bove is a bargain that a prosecutor should not make, right? So in other words, Mayor Adams is the mayor of a city. So we kind of need him to do some things. And we can't have Mayor Adams doing things if he's under federal indictment. So we need him to do these things because there's bigger criminals at play. Look, again, the Mayor Adams case is mostly a joke. If Mayor Adams is guilty, every single congressperson is guilty. So she says it's an undue negotiation, says, look, I remain baffled, says this prosecutor, Danielle, by the rushed and superficial process. And you collaborated with Mayor Adams's counsel and without my direct input, she says, on the ultimate stated rationales for dismissal. Mr. Bove admonished me to be mindful of my obligation to defend the interests of the United States and to advance good faith arguments. Now, I hope you share my view, Pam, in considering the concerns of this, and you can meet with me. Now, in the event you're unwilling unwilling to meet or to reconsider the directive in light of the problems raised by Bove, I am prepared to offer my resignation. She was going to be fired on Tuesday anyways. Now, it has been and continues to be my honor to serve as the prosecutor for the Southern District of New York. Again, one of the most corrupt districts in the entire country. And we've seen what they did to the Harvey Weinstein trial, what they did in the Southern District of New York with Ghislaine Maxwell was there, pretty sure. We've covered so many, but a lot of corruption has been there. Like, why are they doing that? What's weird? What's going on there? So Danielle Sassoon signs it, Southern District of New York. Bye, good riddance. You were going to be gone anyways. Now, what's so interesting about this is not her letter because it's just, a whiny prosecutor. They're very good at whining and being whiny prosecutors. But this is what is fun. This is the response. This came out in direct response to her courtesy of Emil Bove, and he's not playing around at all. Here is what he said in response. All right, Danielle Sassoon. This is from the office of the Deputy Attorney General. Emil Bove tells us, Miss Sassoon. Now, in response to your refusal to comply with my instruction to dismiss the prosecution of Mayor Adams, I write to notify you of the following. First, your resignation is accepted. Pack your crap and get out. This decision is based on your choice to continue pursuing a politically motivated prosecution despite an express instruction to dismiss the case. You lost sight of the oath that you took when you started at the DOJ by suggesting that you retain discretion to interpret the Constitution in a manner inconsistent with the policies of a democratically elected president and a Senate-confirmed attorney general. You think that your authority and discretion supersedes the president and the AG. That's curious, because you took an oath to not do that. And second, now, as you indicated that the prosecution team is aware of your communications with the DOJ, because in her letter, she's like, and I talked to my colleagues, and my colleagues are great. There's okay, all that crap. We all, it's unusual, never seen. Okay, since they're aware of your communications with the Justice Department, and they're all supportive of your approach, your entire team, and the team is also unwilling to comply with the order to dismiss the case. Now we know. Now, accordingly, the other U.S. attorneys who are also principally responsible for this, they're also being placed on off-duty administrative leave. Thanks for letting us know that they're not working with us. And they're going to be investigated by the Office of the Attorney General and Office of the Professional Responsibility, both of which are also going to evaluate your conduct for poisoning the pot and talking to all of your colleagues to have a mutiny with inside the DOJ. So you're in trouble, you're gone, you're going to be investigated, and since you ratted on everybody else, so are they. Thanks. Now, the leave status will remain in effect until further notice. Now, this is not disciplinary or adverse actions, and the U.S. attorneys are going to get paid. They're going to get their full salaries, and they're going to get all their health benefits and go to the doctor a million times a month. While the U.S. attorneys are in an off-duty status, they are not to use their government-issued laptop. They are not to use their phone. Don't use your badge or your access cards unless you're explicitly directed to do so. And while you're on leave, if you're contacted by management, the attorneys must respond by phone or email no later than the close of business the following day. So get out. Don't take anything. Now, at the conclusion of these investigations, the Attorney General will determine whether termination or some other action is appropriate. So bye. Now, based on attendance at our recent meetings, Danielle, I understand that the relevant other attorneys who were also in those meetings are Hagen Scotton and Derek Wickstrom. And Hagen also submitted his resignation, and he cried even harder than Danielle did because he's even worse. Hagen, I think it's a dude, I don't know. Hagen sent another letter in. He's like, I resign, and you're gonna whatever, bye. You're gonna get fired anyways. Thank you for this. No one cares. Get out. If either of these attorneys wished to comply with my directive but were prohibited from doing so by you or mismanagement, or if these U.S. attorneys wish to make me aware of other mitigating circumstances, like if you fingered them but they didn't actually do anything wrong, they can contact my office directly. Otherwise, they're done too. And Hagen's gone. The Justice Management Division and others have taken steps to remove access to electronic devices so that they're sitting there, emails are just cut off. And I ask that you and others cooperate with those efforts to preserve all of your hard copy records relating to this matter, even if they're stored on your personal devices. So we're coming for them. Now, third, under your leadership here from the SDNY, the office, your office, demonstrated itself to be incapable of fairly and impartially reviewing the circumstances of this prosecution at all. And so therefore, the prosecution of Mayor Adams and his case is now transferred to the Justice Department. And we're going to file a motion to dismiss on our own. And my prior directive regarding no further targeting is also in place. And let's give some background on this. So thank you for your little interpretation of how this went down, but here's what really went down. And this is why your corrupt prosecution is now done. On January 20th, Trump issued an executive order saying we're going to stop the weaponization of law enforcement. That includes includes you. Now, your office was not exempted from any of that. On February 10th, I reviewed the cases and I directed you to dismiss the prosecution against Mayor Adams based on well-founded concerns regarding the weaponization and election interference and other impediments that interfere with his ability to govern and to keep New York safe. Now, my memo indicated that I acted pursuant to the authorization of the Attorney General. The mechanism for seeking dismissal is the proper rule, and you should have followed that rule, but you didn't. Now, prior to issuing my memo to you, which instructed you to do this, I reviewed public filings in this case. I reviewed your office's memos, and I reviewed all the classified garbage that you guys had assembled in your files. I met with you. I met with the team. I held separate meetings that involved you, the team, and defense counsel, and I met with you privately in my office. And you noted in your letter that during the second meeting, I did question why a member of the team appeared to have been brought for the sole purpose of transcribing our discussion. Because in her letter, she said that Emil scolded her and the person taking notes. Why are you taking notes in this meeting? You don't need to do that. And she brought the person specifically for that. So that's why, right? She's trying to make him look like he's covering something up. He told me to delete the notes. No, she brought some hack to transcribe the meeting because she was planning this whole operation to create a little media bubble for herself. Who is this dude? Why did you bring this dude here? Why is he writing everything down? Says you failed to note, however, that I made those comments in the context of a conversation about leaks relating to our deliberations, right? So now I'm wondering who's doing the leaking. Probably this woman. Says you were there, and during those meetings, I invited written submissions from both sides. So I did ask for your input, and I did talk to you, liar. Why'd you claim I didn't? And I carefully reviewed everything you sent me. And so your recent suggestions that there was a lack of process are not grounded in reality. Liar! Now, you have not complied with my clear directives or my memo. And further, you made clear you did not intend to do so. During phone calls with myself, you also talked to Chad Mizell, forgot about him, and the chief of staff. You also had a written submission to the Attorney General that day. You also stated that the prosecution team had reviewed your letter and that they would not file a motion to dismiss the case. Then we got your email. Thanks for all those facts. Now you know. Now, the weaponization finding that I have drafted in my memo was made pursuant to a policy set forth by Trump, who is the only elected official in the executive branch, in connection with a decision that was approved by Pam, who was Senate approved, saying we made those decisions. Now, your office has no authority to contest the weaponization finding or the second independent basis requiring a dismissal set forth in my memo. The DOJ will not tolerate insubordination and apparent misconduct, all reflected in the approach that you and your office have taken in this matter. Misconduct. So his memo is in compliance with the rest of the DOJ policy manual, let's say. And they had multiple meetings about this, but she's like, we never know anything, and you were trying to cover this up. He's giving us clear process that occurred in this decision. Also, now you're well aware of the department's weaponization concerns about the handling of the Mayor Adams case. Those concerns include behavior that supports, at minimum, unacceptable appearances of impropriety and the politicization of your office. The investigation was accelerated after Adams publicly criticized Biden, and it was led by a former U.S. attorney with deep connections to the former AG, who oversaw the weaponization of the DOJ. And so based on my review, the charging decision was rushed because the presidential election approached, and as the former U.S. attorney was wanting to be politically appointed in case Kamala Harris won. Wow. So there was probably some pressure from the White House to go put efforts on Adams, and somebody was doing that to get in the Kamala administration. It's sick. Now, as Trump won the election and all of their plotting was doomed, in late December, the former U.S. attorney launched a personal website, which looks like a campaign website that touts articles about the prosecution of Adams, which titles like Damian Williams has come for the Kings, a mayor, a rapper, a senator, a billionaire. Damian Williams, remember him? Meet the man who has prosecuted them all, right? He's like creating his little Rolodex of prosecutions because he's a corrupt person. And this is how prosecutors think. They don't care about your presumption of innocence or who you are. They just come get you because they're corrupt. Damian Williams, he wrote this article, flexes New York power against Adams and Sean Combs, right? And the Sean Combs case, right, as horrendous as it is also looking like, what kind of indictment was that? Similar thing, right? He's just ratcheting these up like notches on his belt. It's pretty sick. Even though these are not esteemable people in any sense of the term, they still deserve process in America. The former U.S. attorney increased the appearances of impropriety. He also released an op-ed saying an indictment of the sad state of New York, indicted the mayor. He disparaged Mayor Adams, says America's most vital city is being led by a broken ethical compass, and only he he can help. Because he's going to run for office, obviously. Yet, you did not directly defend his behavior, did you? In your little filing, did you? Nor could you. His actions inappropriately politicized and tainted your entire office. Maybe permanently, yeah. Instead of addressing these concerns with the district court, you simply claimed that these were beside the point. Why? Because they're inconvenient for you. Yeah. Not true. In fact, it's very much the point. The action by Damian Williams implicate the concerns that Trump has raised about the weaponization of the DOJ. The fact that the district court denied the defense motion does not establish that the continuing prosecution is some approval of your discretion to do this. And similarly, the fact that other attorneys convinced the grand jury to return an indictment based on a one-sided and an inherently impartial presentation of the evidence doesn't mean anything, as we mentioned. The DOJ is not going to ignore the fact that the timing of the charges that were authorized by Damian Williams interferes with his ability to run an election. Oh yeah, so when Damian runs for the mayor, then his opponent will have an ongoing criminal indictment that Damian Williams was originally initiating. Your reference to the schedule of underlying prosecution of Menendez is not persuasive at all. Now, if anything, that experience counsels in favor of more caution, not less. But the record doesn't reflect the caution. In fact, in October, the prosecutor responsible for prosecuting Adams represented, quote, that the first batch of discovery was about 560 gigabytes of data, which is crazy. Thus, as a trial date was negotiated, Adams was faced with the impossible choice of trying to defend himself at a pre-election trial or actually reviewing the discovery at a post-election trial. They did the same exact thing with Trump and the January 6th case, if you recall. It's the same thing. Now, in your letter, you made the dubious choice to invoke Justice Scalia. Oh, see, that made me mad too. Now, as you're likely aware from your professional experience, Scalia actually understood weaponization and lawfare. Love this, so shove it right back down her gullet. Now, nothing is so politically effective, says Scalia, as the ability to charge that one's opponent and his associates to charge that they're not just wrong-headed, but that they're actually crooks. Not that they're dumb, not that they're idiots, not that they're just misguided, but they're criminals. They broke the law. They're ending democracy. And nothing so effectively gives an appearance of validity to those charges as a DOJ investigation and a prosecution, right? And that's Scalia. He said that back in 1988. I don't know how applicable that is anymore. I mean, the DOJ is still obviously applicable, but the DOJ by and large has wrecked its credibility. So has the court system. So now I think a lot of people, it's like going to be the same thing they did to the CDC, right? CDC were like, wow, they're going to take care of us and prevent disease. Then we're like, wow, they like misguided us pretty badly on that one. DOJ is going to have the same reckoning. It's happening. We're going through it right now. And the courts, especially the DC circuit, is also doing the same thing to themselves. Now, Emil says, there is also great irony in your invocation of the famous speech by Attorney General Robert Jackson. His remarks are unquestionably relevant here, but not in the way you think. Jackson warned that, quote, some measure of centralized control over federal prosecutors was necessary. The senior leadership of the DOJ exercises that. And one of Jackson's concerns was that the most dangerous power of the prosecutor arises from the risk that the prosecutor would pick people that he thinks he should get rather than pick cases that need to be prosecuted, right? That is what has been perverting our government for years now. Now, regardless of how the investigations of Adams was initiated, by 2024, your office's work was extremely problematic. And finally, your suggestion that Trump should issue a pardon to Adams reveals that your office's insubordination is little more than a preference to avoid a duty that you regard as unpleasant and politically inconvenient. Your oath, Danielle, to the Constitution does not permit you to substitute your policy judgment for that of the president or senior leadership of the DOJ. And you are in no position to suggest that the president exercise his exclusive authority to make your job easier. And so for all of these reasons, we're dismissing it. Your refusal to do that has only exacerbated the concerns that I thought existed initially. And finally, your objections to the second basis for my directive, I said that Adams can't do his job if he's under indictment, are based on exaggerated claims that further illustrate your ability to grapple with the problems of this case. Now, as a result of the pending prosecution, Adams is unable to communicate directly with the city officials he manages. He has been denied a security clearance that limits his access to details of national security issues in his own city. He can't speak to federal officials about imminent security threats, can't cooperate with the federal government. The situation is unacceptable, and it directly endangers the lives of millions of New Yorkers. Now, my directive to you reflected a determination by the DOJ that these safety risks greatly outweigh any risks you've identified. It's not for local federal officials like you, who lacks access to all the information, to question our judgments. And you claim to find my reference to Victor Boot, the Russian merchant of death to be alarming, but you have missed the fundamental point, obviously. Presidents frequently make policy decisions that the DOJ is charged with implementing. Now, in connection with Boot, Biden made a very questionable decision to release the merchant of death from prison. But once the decision was made, it was the responsibility of your office to execute it. And regardless of anyone's personal positions on this, your office filed a decision to release Victor Boot. So you did it there. So release Mayor Adams, okay? He's not the merchant of death. He just likes nice flight upgrades. That was your job, and the job of the attorneys assigned here. You have all violated your oaths by failing to do it. In no valid sense do you uphold the Constitution by disobeying direct orders to implement the policy of a duly elected president. And anyone like you who is romanticizing that behavior does a disservice to the nature of this work and the public's perception of our efforts. And you have also strained unsuccessfully to say that there was some kind of quid pro quo. Totally false, as you acknowledged before in writing. Even you said that. The Justice Department is charged with keeping people safe across the country. Your job is to try to help keep the city safe, but your actions are endangering it. And more broadly, you're simply incorrect that there's no valid basis to seek a dismissal. And that contention is a dereliction of your duty, Danielle, to advocate zealously on behalf of the United States, the oath you swore to uphold. The main case you cite is this case, talking about expense and inconvenience. That's why they didn't dismiss that. That's not what we're talking about here. You're relying on a 57-year-old district court case? What are you talking about? The Attorney General has an absolute right to dismiss this, as this case says. Any judicial discretion is severely cabined to these other contexts, and so any concerns that you guys made up about, oh, we can't dismiss this because of case law, says that's ridiculous. They were not a valid basis for your insubordination. And so finally, and to be clear, while I elected to address two particular concerns in my memo, I have many other concerns about the case. So you screwed up on these two reasons, but I could have blasted you for a bunch of other stuff too. In fact, the case turns on factual and legal theories that are at best extremely aggressive, which was our read of it from the beginning. You can go back and watch the tape. We're reading this going, what? He got like upgrades and stuff? Like, okay, he probably got some financial benefits and so on and so forth, but he didn't do anything worse than Fannie did. Fannie's case was way worse, and she didn't get indicted. She got reelected. They love her in Georgia, in Fulton County at least. It was like the same thing, right? Fannie and her lover, they got $700,000. I don't know that we had anywhere close to that with Mayor Adams. You got like some flight upgrades to Turkey or whatever. For example, the district court explained that it's not inconceivable for the Second Circuit to hold that an official act, it might be applicable here. The district court also acknowledged that there is some force to Mayor Adams' challenges as to your theories, and that things of value in this case, you call them campaign contributions, which would require heightened proof. And as the office knows from the challenges you encountered in another decision where that case was dismissed. So in other words, you knew this was a weak case and you brought it anyways. There are also questionable behavior reflected in certain decisions that your team made, which we're going to look into in our forthcoming investigation. So get ready for that. Witnesses in the case do not appear to have been treated in a manner that is consistent with your claims about the seriousness of your allegations. It's my understanding that around the time the charges were filed, the prosecution team made representations to the defense counsel that are inconsistent with the Justice Manual and their definitions of a target and subject. Now, in the same period, despite already having started to draft a memo, the team invited Adams to a proffer. So they're scum. In other words, they had already made up their mind to prosecute him. Once they made their mind to prosecute him, he had to be treated accordingly, and they didn't do it that way. They started to draft the prosecution memo. They said, why don't you come in here and give us a bunch of evidence? They baited him into making unprotected statements after lying prosecutors had already decided they were going after the guy. Corrupt prosecutors, no doubt. And he says, Emil from Trump's DOJ says, I take no pleasure in imposing these measures, initiating investigations, and requiring personnel from the Justice Department to come to your district to do work that your team should have done and is required to do. But in this instance, however, that is what is necessary to continue the process of reconciliation and restoration of our core values at the DOJ. And so, you're fired. Get out. Here is the president getting asked about that today.
Adams' case resigned today, saying anyone who didn't press forward would be a coward. What's your reaction to that and to the overall implication that politics were at play here?
Well, I don't know about it. I mean, obviously, I'm not involved in that. But I would say this, that if they had a problem, and these are mostly people from the previous administration, you understand, so they weren't going to be there anyway. They were going to all be gone or dismissed. If not, they know on Tuesday they're all being dismissed. You know, the whole country is being, because what you do is you come in and you put new people in. So when you say resign, they're going to be gone anyway. But I know nothing about the individual case. I know that they didn't feel it was much of a case. They also felt that it was unfair with the election. Look, I would know that better than anybody. because
Yes, you would.
I was weaponized more than any human being in the history probably of the world. And I won the election in a landslide, winning all 7 swing states, winning the popular vote and everything else because the people got it. It was weaponized. And I was weaponized literally weeks before the election. But I think there's also something to be said. I read that. There's something to be said for what they were doing. It looked to me to be very political. But why didn't they bring this up like 4 or 5 weeks ago, 6 weeks ago, or whatever it happened? You know, they just sat around and didn't complain. Then all of a sudden they complain, and they know they're all being dismissed anyway.
Yeah, so they're just doing it to make a name for themselves on the way out. It's a moral little preening. Oh, look how amazing I am for resigning and objecting to Trump. They'll all go get jobs at some lefty law firms or end up on MSNBC, but they're gone. Others are joining them soon, and we're here for it.